get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll play it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning.
All right, guys, welcome to the show. Thank you for tuning in today. And today's topic of the show is going to be the motion to dismiss hearing. Now, we have heard from heard depositions that have led up to the contents of this hearing, which is why we played those. One individual that we're going to play down the road potentially, but I think the pertinent information's been heard. One follow-up I want to do is the deposition of Chad Zabilia. So Chad Zabilia was the individual, the IA investigator that investigated the mishandling of evidence in the case, and he was deposed as part of the Penny Phelps investigation, or not investigation, lawsuit, I guess I should say, which we heard, of course, Penny Phelps' deposition. But a lot of what was contained in that, you heard Penny Phelps get cross-examined on yesterday in explosive testimony, where Phelps was confronted about the allegations leveled at her by Mr. Tucker and his defense team. So today, this is the culmination of essentially 6 years of investigation, because Mr. Tucker's team investigated this case for 6 years leading up to this motion. They went to court and they unveiled all of the misconduct. And this is, you've heard a lot of this stuff be talked about by Ty in online interviews, press. But this is where you're going to actually hear from his attorneys. This was the last hearing he had an attorney come to and argue his case. And you're going to hear potentially what you would have heard at trial if his attorneys were taking over and their opinion of the case. But most importantly, you're also going to hear from the prosecution in this case, as they are confronted by attorneys and not Ty Tucker regarding the lack of evidence in the case. And essentially, Mansfield, in a defensive posture, as Ty's attorneys take apart all the evidence, they dismantle all of it. And essentially, Mr. Mansfield is left arguing to the judge that John Travis Johnson's testimony is the only evidence they have. He acknowledges it. He says, we have nothing else. John Travis Johnson's testimony is what we're relying on. And we believe the jury should have an opportunity to hear from John Travis Johnson and determine whether or not they believe that he's credible or not. And that's essentially what the case comes down to. Now, unfortunately for Ty, he has struggled to understand that testimony is evidence, regardless of the reliability of that testimony. John Travis Johnson holds out that, the story that Penny Phelps fed him, which is easy to see by an individual observing this case from beginning to end, that John Travis Johnson was fed this story. Now, John Travis Johnson originally was fed this story, was charged. He didn't believe he was going to be charged. If you watch his interview tapes, he was trying to avoid going to jail. He ends up in jail for 5 years. He ends up with public defender, and then he ends up hiring an attorney, and then eventually they work out a deal for him once it becomes clear that all the tactics of the Monroe County, which you're going to hear about. You're going to hear about all those different things. Once they realize that Raheem Jackson isn't going to work out, the DNA hasn't linked Todd Tucker to this case, that there is no eyewitnesses. The camera evidence is destroyed or lost or gotten for the wrong day. Essentially, all of the evidence in the case that they thought they had, that the confidence that was exuding out of the police in the early days of this investigation, it becomes clear they got nothing. So the only person is going to be an individual willing to testify, and at that point, it was Rory, Tucker, or Johnson to come forward, strike a deal, and get a get out of jail free card. Tucker was out on bond, and he was feeling pretty confident that there was going to be no ability for the state to prove their case if nobody turned. Rory Wilson couldn't come up with a story that made sense, and he had DNA linking him to the knife, the mask, and the crime scene. And John Travis Johnson. Now, John Travis Johnson, there's no DNA of John Travis Johnson anywhere, much like Tucker. But John Travis Johnson's truck is seen at the scene. So there was actual evidence linking John Travis Johnson to the scene. So he flips, makes a sweetheart deal, and he becomes the evidence. And then you have Tucker, who has no evidence. There's no DNA. There's no eyewitnesses. There's nothing linking him to the scene. There's only one witness, and that's John Travis Johnson. And that's where the problems begin with this case. Everybody can sit here and say, oh, it feels like this, it feels like that. But the bottom line is, when the only witness to your case is John Travis Johnson, that is the problem. There is nobody else that links him to the case. And when you get into, and I'm going to be playing in a subsequent show, I will be present fully for that. We will be breaking it down because I have enhanced the interrogation room tape that lost Penny Phelps her job. But in that tape, you can hear the early theorizing going on about the case and what Penny Phelps thinks about the case and where the police are going with this case. And you can see, as I've always said, this case is as simple as just them getting it wrong. Penny Phelps firmly believed Tucker was the white guy. And that was solely based on the fact that he showed up at Metro PCS and that William Peoples gave them information to say that a white guy and Rory were at Burger King and were told that there was an opportunity to go hit this place up for money and drugs. And from there, this whole scheme, this whole situation develops. And then you have, Rory Wilson showing up with a white guy at Metro PCS, money being used to pay a phone bill, and these guys think that, hey, this is the moment. This is the guy. And that's what they think. And then they're not anticipating that there's anyone else involved. You can actually hear them looking at the picture. You can hear Penny Phelps saying, oh, that's our guy. Look at him. Oh my God, look at that picture. That's the Facebook picture. But what you can also hear is John Travis Johnson, he's fleeing the island. Rory Wilson, he's changing his appearance. One thing that stands out is they're sitting there almost saying, I can't believe it, but this guy's got a long goatee. So Todd O'Quinn's got to be able to identify him. That's an identifying factor, because when he pulls the mask off, we know Todd O'Quinn's going to have seen that beard. And that's important because that's where their mindset's at. But what happens is as this investigation proceeds and they go out and they pick Tucker up and they pick up Rory and they bring him in, and Tucker doesn't go along, and Rory is saying, what the hell are you talking about? And then John Travis Johnson enters the conversation. But yet Penny Phelps has moved on Tucker. And for some reason, Tucker pisses her off. She doesn't like it. And she says, this guy's got to be involved. And she's figuring, hey, maybe she can, I think in her mind, it starts to develop where she's thinking to herself, well, she doesn't want to let go and say, hey, I'm wrong on this, because she's taking lead on this. This isn't like her being a captain getting briefed. She's actually investigating this. And she believes she's going to crack this case wide open. And then eventually her whole case starts to unravel, because Tucker, there is no evidence linking him. And that's why you hear in the final interrogation room video that I'll play, you hear them say, if Todd O'Quinn doesn't identify Tucker, we're going down. This whole thing breaks up, because they knew that this whole thing rested on, that's all that was linking him. And if the DNA doesn't link him, we're in trouble. Because she decided, we're going to roll on this Tucker guy because I just don't like him. I don't like how he looks. I don't like how he talks. I don't like how he acts. So they arrest all three of them. She goes into John Travis Johnson, who essentially confesses, regurgitates her confession. Because why? Because he needs to. Why? Because, well, he is looking for a way out of this thing, because he did it. Because he was the guy that was there. He was the guy that was there with Rory. And Todd O'Quinn doesn't identify Ty. In fact, he doesn't say anything, if you look, about a goatee, which is why the Jägermeister gator has to come in. But here's another problem. No one sees a Jägermeister gator. Not Roger Ruggett, not Paula Belmont, not Todd O'Quinn. Everyone is adamant. 2 Skeletor's type masks. That's what's the description. That is a consistent description among all witnesses. There is nothing that says a Jägermeister gator was used, except for John Travis Johnson. And that's a problem, because John Travis Johnson makes up that. And they get stuck with that. And that's what he's saying in that interrogation room, because he's just making shit up. And, here we are. So all that's relevant, because I want to give you background on it as you're looking at this motion to dismiss, because you want to put all that into effect. Because when you're going to hear the arguments, you're going to hear Bellarito argue this case before Judge Jones, and it's very interesting. So pay attention. So I do apologize. All of these things have had to been done with AI voice, because they're transcripts. So I want to be able to do a presentation where you can listen to it while also reading. Now, this is being done today for a specific reason, because today is Ty's birthday. So leave him a birthday wish, because this is a link to his Facebook. When he gets out, he's going to see it. When you come into these lives, these are a link to his Facebook as far as the YouTube presentation. So come in, leave a comment. Live chat is always gets left on, but the best place is leave a comment. Leave a comment for Ty of support of what you're thinking about the case. Let them know you're there. Let them know you're a supporter, because this is about getting the word out. So today, this is I know I'm doing this today for a specific reason. Number one, he is in court for his final pretrial hearing. And he is filing an important motion today. I understand that he's going to be attempting to get the judge and prosecution disqualified from the case. I don't think he's going to have success doing that, because of just without lawyers, this judge is going to be able to say, denied, we're going to trial, Mr. Tucker. And Mr. Tucker will have to seek Third Circuit appellate intervention, and we'll see if he's successful doing that. But today he'll appear for what will be potentially his final pretrial hearing. While on top of that, this is Ty Tucker's, this is the baby right here. This is the whole thing. If you talk to Ty and you say, and he wants to tell you about his case, he'll send you the order that emanated from this hearing where Judge Jones turned it down. He'll send you the motion to dismiss, and then he'll also tell you about this hearing that occurred, and he'll try to tell you everything that happened at it. Well, never before. He's always had to provide everybody with this 100-page transcript. Now you can just come and watch it and listen and have it spoken to you. And while it's not perfect, it's not human necessarily, but it will allow you to read it and listen. And if you want a copy of the transcript, you can go to the Monroe County Clerk's office and download it, or you can reach out to me at Justice as a Process, and I'll respond to your email and send you a copy of this transcript so you can have it, share it with other people. If you're trying to get an attorney that you think might be interested, involved, you can show it to them. Anyways, with that said, guys, we're going to go and get this hooked up, and let's Let's make sure we got everything hooked up here. We're going to switch in and get our TV up. So there it is. That's the transcript. And this hearing took place. Give me a moment here. I'll tell you guys. I want to tell you when the hearing took place. I believe it was in July. I want to say it was like July 2020 something. Let's see here. Treehouse docs. Motion to dismiss. All right, there it is. This took place July 14th, 2023, at the Freeman Justice Center. So in the same courtroom or the same courthouse, I don't know if it was the same courtroom to which you saw Ty tried it. So envision that as you're listening. Bellarito appeared. I think what is his name here? Let's see who appeared in that. They're going to say the names. So who was appearing was Jerome Bellarito of Bellarito Law or Bellarado Law. I think it's Bellarado, and Kara Higgins, and Joseph Mansfield appeared with Kathleen Cortez. They appeared on behalf of the state. Cortez argues the law, Mansfield argues the evidence, and Jerome Bellarado. I don't think Kara Higgins even argues in this case. I think it was all Bellarado who's arguing. And, this was the hearing that Ty put all of his hopes on, because he really believed that the judge was going to have no option but to dismiss. And ultimately, well, I understand why Ty felt frustrated, but the decision to not dismiss this case, as you're going to hear one other little side note before we hit play and get this thing going. One thing I wanted to clarify here is while I understand Ty's frustration here, the reason why Judge Jones ultimately didn't dismiss this case was not necessarily out of corruption. And I understand how Ty feels, because Ty's like, this guy, it should be dismissed. It should be blah, 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 blah. But essentially what happened in this case was the core argument for the motion to dismiss, as you're here, is the state lied in the grand jury. And when the state lies in a grand jury, if they put up knowingly false testimony, and the idea was that Pitcher lied about the existence of Potato Quinn. He lied when he said that there was nobody, basically he was asked the question, is there anyone else? Is there anyone saying it could be anyone else? And he said no. Of course, Potato Quinn was saying, not only was he saying it could be anyone else, he was saying the guy didn't fit the description of Ty, that he looked at a lineup of Ty and it didn't identify him. So the idea was if this information would have hit the grand jury and they would have been aware, it's very unlikely that at that point they would have indicted Ty Tucker, because they literally had no evidence, and Raheem Jackson wasn't available. But Pitcher, what Pitcher had told the grand jury, because when you testify before the grand jury, you're allowed to do what's called double hearsay, at least for purposes of a police witness. So the investigator of the case oftentimes gets called, and he will talk about what other people are expected to testify to based on his investigation. So what he told the grand jury is that they had talked to John Travis Johnson, and that John Travis Johnson said that he was the driver and Rory and Ty were the assailants. And he basically related to the grand jury what John Travis Johnson said, and that there was an expectation that John Travis Johnson would be cooperating by the time trial came around. And that's it. I mean, that was literally what the grand jury was left with. Now, what could have helped, obviously, in considering this would have been the knowledge that Tato Quinn and Paula Belmont both said that Tucker wasn't there. That was never shared with the grand jury. So Tucker's attorney said, well, this is a due process issue because if you lie to the grand jury, and Pitcher did lie to the grand jury. He lied about Todd and Quinn. He lied, and you're going to hear specifically, you hear all about that. It's a due process issue. And one of the remedies for a due process issue is potentially to dismiss with prejudice, meaning they cannot refile. The other remedy is, and you're going to hear that Ty Tucker's attorneys were suggesting this, was to dismiss without prejudice and allow the state to represent the case to the grand jury properly with the knowledge that Todd O'Quinn is available to testify, and to do it properly and then indict. And what Judge Jones found in the case is he said, okay, because what Mansfield ultimately argues is, well, the case hasn't changed that much, Your Honor. While, yeah, there was all this dirty stuff that went on. There were informants that they tried to do. There were jailhouse snitches. At the end of the day, the fundamentals of the case have never stopped. We don't have physical evidence on Mr. Tucker. We don't have anything linking him to the case. The only thing we're bringing this case based on is his alleged co-conspirator's willingness to testify against him. So we're telling you today, we're holding to the court that John Travis Johnson is willing to testify. He's willing to come to court, and that is evidence, Your Honor. And if that is all we have, and we can present that, the jury is allowed to consider that. And Mr. Tucker is allowed to come to court and confront the credibility of John Travis Johnson, and the jury is then allowed to deliberate on whether they believe him or not. And essentially, Judge Jones said, well, okay, you're right. That's true. And that is true. And then they said, listen, we believe. So now the issue is, we acknowledge all the issues you have. The question is, does the lies that were presented to the grand jury rise to a due process issue that says this should be dismissed with prejudice or not? And you're going to see Tucker's own attorneys vacillate on that. Had they come in harder and brought more case law in and said the only remedy when you lie to a grand jury, you can't undo that. You can't unring that bell. They got one chance. They came in and they did this, and a prosecutor lied, and the case law is clear. This case needs to be dismissed, and it needs to be dismissed with prejudice. Then that would have been something that would have put the judge in a box. But Colorado doesn't do that. He gives the judge an out, and he says, we would, because what he was trying to do was just get it dismissed. And he was trying to say, give the judge a fallback, which was stupid, because unfortunately the judge said, well, there's another way to look at it. If I fall back to that, now I'm going to take the position, and the appeals court can tell me I'm wrong, that once I determine that a motion to dismiss with prejudice is not the remedy, now I look at it and say, well, okay, so I could dismiss it and it could go back before the grand jury, or I can now make a determination whether probable cause exists. If I say, okay, I would dismiss this for the purpose of sending it to the grand jury, but let's just take a look here. Does probable cause exist when you take all the bad apples out of the bunch? And he basically said, well, no, it does not, because at the end of the day, John Travis Johnson is what the grand jury was told existed. That's what they really indicted him on. And if they were to represent, John Travis Johnson's just going to go before the grand jury, tell the same story, and an indictment's going to happen. So we're going to go ahead, and I'm going to deny the motion to dismiss. I'm going to, and then we're going to move on to trial. Now, what was going on behind the scenes with Mr. Tucker and money and everything else that cost him to fire his attorneys after this, I have no idea. But the reality is that there was no need for him to fire his attorneys. He should have absolutely brought them to trial. There was certainly no need for them to charge him $200,000 or $1 million or anything like this for a case this simple, because the only thing this case was going to consist of was John Travis Johnson. The DNA expert, I don't think the state would have ever put the DNA expert on the way they did, because the experienced attorney would have argued that that's reasonable doubt. And if Ty would have entered that courtroom with attorneys, they would have absolutely destroyed, in my opinion, John Travis Johnson, and we would have had an acquittal. This is an easy acquittal, and it would have been easy. But That's not how things unfold after this hearing. But anyways, I want you guys to hear this and I wanted you guys to understand that, because it takes this case and it really puts it down to a simple thing. Do you trust Travis or not? It's not do you trust Ty, it's do you trust Travis? Because out of the words of what you're here, Prosecutor Mansfield tell you, John Travis Johnson is the only piece of evidence linking Ty Tucker. If he goes bye-bye, if he falls apart, case goes bye-bye, in the words of Mark Furman in the OJ case, when he said, if the glove goes, bye-bye to the case. If John Travis Johnson goes, bye-bye to the case. And it's still that simple today. So it's going to be a matter of how Franklin Tucker can confront John Travis Johnson next month and whether he's successful in destroying his credibility. And if you look at all the pretrial machinations, all the movements that they've done, they're trying to limit the ability for Tucker to destroy John Travis Johnson. And now they're trying to bring in this knife business because Tucker testified and suggest that Tucker gave up some information that now makes it look like he knew about blood being on a knife when he shouldn't have. And that's going to be the simplicity of their case. And they're hoping that between John Travis Johnson's testimony and the blood on the knife, that they're going to be able to go, this is overwhelming evidence. This guy was a co-conspirator. He's trying to come into this court. He's trying to mess with this court. He's trying to say he's innocent, and he's not. But the reality of the situation is, if you know this case, you know John Travis Johnson and Roy Wilson were the two guys that were there that day. Tucker was sleeping off Fireball, a day of drinking Fireball, and it's that simple. But nothing's that simple in this case, right? So anyways, with that said, let's jump into the hearing here and get started.
The court, good afternoon. This is Circuit Judge Mark Jones. The defendant, good afternoon, Judge. Franklin Tucker, defendant. The court, okay, sir. You're on a speakerphone in Courtroom B in the Freeman Justice Center, downtown Key West. I'm Circuit Judge Mark Jones. The case set for hearing this afternoon is State v. Franklin Tucker, 17 CF 841C. It's the defendant's motion to dismiss. We have Ms. Higgins and Mr. Ballarotto here on your behalf. Mr. Mansfield and Ms. Court here for the state. This has been set for 2 hours. By my courtroom clock, it's 1:37. Each side would get an hour. That would be for a first and a second argument divided up as they see fit, but 2 hours is what we set. It should be plenty of time, and that's what you got. So that being said, is defense counsel ready to proceed? Mr. Ballarotto, we are, Judge. Good afternoon, Your Honor. Thank you for having us here today and for giving us this time. We're here today on our motion to dismiss the indictment and the information. What Kara and I have done, Ms. Higgins and I, we have divided up the presentation to most efficiently present the facts, I mean the issues, and discuss the law and suggest the inevitable conclusions. Now, we'd like to start with saying that, in response to our motion, the state asserts this proposition: the state categorically denies any allegations that the evidence presented to the grand jury was perjured or manufactured. They state this proposition that, to the extent any of Detective Pitcher's testimony during the deposition, or any other facts, disagree with the testimony given during the grand jury proceedings, the testimony was either based on facts learned subsequent to the grand jury or the normal product of placing a witness on the stand. They further say that our allegations consist of nothing more than unsubstantiated conspiracy theories and personal attacks against Ms. Dunn, Ms. Phelps and Detective Pitcher. Now, as I said, we're going to divide this up. But in response to the state's claim, Ms. Higgins will present the facts of the case. She's going to present a PowerPoint to Your Honor and to the prosecutor. She'll present the facts. She's going to show you who did what did they know when they did it and said it, and how did they know what they knew when they did it and said it, and then what was done in the grand jury and stated in the information. I will discuss the law and suggest conclusions after. And following, after knowing these facts, the prior conduct of Dunn, Phelps and Pitcher, it is important to understand their willingness to totally disregard the principles of the United States Constitution, the Constitution of the State of Florida, as well as the Florida Supreme Court. An understanding of these factors will put the lie to the state's claim of unsubstantiated conspiracies and personal attacks. Let me just mention this to you, Judge. You may wonder, we have been at this for so long, why are we here now? Why are we here in 2023, when this case was indicted in 2017? The fact of the matter is displayed on this PowerPoint. We made our first motion to obtain these grand jury transcripts 3 years ago. And Colleen Dunn, while she was managing this case, fought and resisted our obtaining these grand jury transcripts. Why? Well, at the end of 2022, the new state attorneys who took over the case, Mr. Mansfield and Ms. Garcia, courts, agreed to give us the grand jury transcripts. And I suggest to your honor that, I will say to you that what we suspected was in those grand jury transcripts proved to be true, and now you will learn, as we know now, why Colin Dunn objected so hard to giving us these grand jury transcripts. Ms. Courts, object is to relevance. The court, I'll overrule the objection. It's just argument. Mr. Ballarotto, Judge, at this time, I'm going to let Kara Higgins begin. The court, okay. Ms. Higgins, good afternoon, Your Honor. The court, good afternoon. I just want to be sure the state can see the screen sufficiently. Ms. Courts, we also have, the defense has been kind enough to provide a hard copy of the PowerPoint presentation. So even if we can't see the screen, we can go ahead and follow along. The court, all right. That's fine. I was just going to say, if you needed to resituate yourself or have the screen moved, but, otherwise, you're all set. We'll keep going. Ms. Higgins, thank you, Your Honor. Your Honor, as Mr. Ballarotto informed the court, I am going to be doing my best to present, not all the facts, but some of the most egregious that we have discovered in the grand jury transcripts that we now finally have. The state's response, again, what Mr. Ballarotto said, is that if Detective Pitcher's testimony somehow disagrees with what he subsequently said at his deposition, it was because he just didn't know it at the time that the grand jury proceeding was taking place. And, unfortunately, Your Honor, that's not true. And it wasn't just Pitcher. Dunn and Phelps also knew the evidence presented to the grand jury was perjured at the time of the grand jury presentation. At his deposition, Pitcher testified that he believed Penny Phelps manufactured evidence in the case by leading witnesses down a road. Unfortunately, Dunn and Pitcher presented this manufactured evidence as truth to the grand jury. Detective Pitcher took an oath before he testified before the grand jury, solemnly swearing that the testimony he gave them would be the truth, the whole truth and nothing but the truth. Our statute defines perjury as whoever makes a false statement in which he or she does not believe to be true under oath in an official proceeding in regard to any material matter. Serious crimes. Felony of the third degree. Perjury extends to omissions of material facts and statements made in reckless disregard for the truth. Subornation of perjury, Black's Law Dictionary defines it as the offense of procuring another to take such a false oath as would constitute perjury in the principle. We have Florida bar rules requiring lawyers to take reasonable remedial measures when the lawyer knows false evidence has been offered. And prosecutors have special obligations. A prosecutor who permits a defendant to be tried upon an indictment which the prosecutor knows is based on perjured material testimony without informing the court, opposing counsel, and grand jury violates due process under the Florida Constitution. Detective Pitcher told us that Colin Dunn was as equally involved in the investigation as Captain Penny Phelps. Decisions were made by Phelps and Dunn without Pitcher's knowledge. Decisions about April Walker, Anthea Clay, interrogations, interviews and a search warrant execution were done without him, and that Phelps spoke with Dunn about everything she did in this case. Yet the defendant has not been allowed to speak with her. The defense listed Dunn as a witness to inquire about what she did during the investigation of the case. At the request of the state, we were ordered to strike her from the witness list, and we have been repeatedly denied the right to depose her. She knew what she did in front of the grand jury, and the state attorney's office has had the grand jury transcripts for over 5 years before we got them. We did not have the benefit of those transcripts when we deposed Pitcher. But the state appears to want to continue to hermetically seal Dunn from questions about what she did in this case and why. And in the event that this indictment and information is not dismissed, the defense is severely prejudiced by being barred from inquiring into the acts of a witness who acted as an integral part of the investigation team. And we can only conclude that, by doing so, the state attorney's office is subornating, phonetic, perjury. Pitcher told us that he lost control of the investigation to Dunn and Phelps, that they ran the case, and that when Phelps gave you an order, you better follow it. Otherwise, there were consequences. But he didn't tell the grand jury that. When asked, what role did you serve in that investigation, he said, I was the lead detective for investigating the crime. He didn't tell the grand jury that he lost control and that the prosecutor who was presenting his testimony and another former police officer were actually running the case. When they started their presentation, they immediately lied about the primary suspects of the case, the court, I'm sorry. When who started their presentation? Ms. Higgins, Colin Dunn and Detective Pitcher. Colin Dunn presented the case, and Detective Pitcher was the only witness that she called. Colin Dunn asks Detective Pitcher, so at this point in time in the investigation, between the information you received from Todd and Paula, how many suspects are you looking for? He responds 2. And what name are you looking for? What name was given by Paula? Answer, the only name we had was Detroit. Colin Dunn was at the scene that night. She knew Anthea Clay had been named by Paula dozens of times at the scene. Anthea Clay's name was the first name of any suspect that went out over the radio. She knew this was not true, and she led Pitcher by suggesting there was only one name. This is not the only time she elicited false testimony. She then asked Pitcher at another point in the examination, "Did you pursue an arrest warrant for Tucker?" He answers, "Yes, we did." It was a lie, and she knew it. Pitcher told us that he told Colin Dunn that he did not believe there was enough evidence to even arrest Ty Tucker for this crime, much less indict him. Dunn then spoke to Phelps, and after that conversation, Phelps ordered Danielle Malone to write the arrest affidavit. But yet Dunn called Pitcher, a witness she knew didn't even believe he should be arrested, as her only witness in the grand jury. She then prepared him to commit perjury. They addressed Todd O'Quinn. They told the grand jury that Todd O'Quinn saw a man, the second suspect, run from the treehouse, lift his mask, and that he could tell he was white. They never told the grand jury that Todd O'Quinn described the second suspect as having curly brown hair and different weight and height to that of Tucker. They never told the grand jury that O'Quinn told Pitcher he personally knew Tucker and that it wasn't Tucker. He never told the grand jury that they presented O'Quinn with a photo lineup containing Tucker's photo, as well as a photo of co-defendant, turned state's witness John Travis Johnson, and that O'Quinn told Pitcher that the second suspect looked most like Travis. Pitcher also didn't tell the grand jury that before Tucker's arrest, when Phelps came to her own conclusion that the other white guy they were looking for was Tucker, that Phelps said, "I hope Todd can ID him. Otherwise, Jesus Christ, we're all in trouble." What's worse, after they showed the grand jury the body cam video featuring O'Quinn, Dunn asks Pitcher, "Did you do a better interview of O'Quinn at a later time?" "That's correct." "Were you able to get more information than what you heard of the distorted audio?" "Yes." "And that's it?" She doesn't ask any follow-up questions because she knows what Pitcher heard was that O'Quinn continually repeatedly says, "It was not Tucker." She leads the grand jury to believe that there's more evidence that corroborates what he told her in subsequent interviews when there's not. And over again, she misleads the grand jury. Pitcher testified there was physical evidence implicating Tucker. She led Pitcher to say that Tucker was, quote, "quite a bit smaller than Mr. Wilson. He's pretty skinny." A few minutes later, she leads him to say that clothing contained in Wilson's bag were very small and would not fit Wilson, not to mention the fact that there's actually no evidence of this. Pitcher tells the grand jury that he found dark clothing or a pair of shoes that had a substance on there to be sent to the lab for testing. It's clear he used or to recover his testimony. He meant to say shoes, because he already implied that Tucker's very small clothing were found in Rory's bag. It wouldn't make sense that the same clothes were found in two separate places. And he tells the grand jury that it appears to be blood on the shoes. The grand jury never heard the truth. There were no bloody clothes. There were no bloody shoes. And there was no physical evidence linking Tucker to this crime. They talk about April Walker, and they present the grand jury with hearsay within hearsay within hearsay. Detective Pitcher tells the grand jury that, through Penny Phelps, April Walker has told the police that Tucker was angry with her. He was nasty with her. He knew that she talked to the police, and that he told her that if she talks to the police again, he's going to kill her or hurt the baby. He tells the grand jury that Ty said, "I'm the one who set your husband up. I'm free. He's not. I was able to lie my way out of this. That's why I'm free and he's not. If the police come here, I will know you called them, and I will come and look for you and your baby." And at that point, she locked the door. The problem with this hearsay within hearsay within hearsay testimony, Your Honor, is that Pitcher told us that he agreed that these statements allegedly made by April Walker actually came from Captain Phelps' mouth and were just parroted back to her and then repeated, "Excuse me," then parroted back to Phelps by April Walker. Pitcher admitted that Phelps told Walker to say these things. He admitted there was no evidence the defendant ever threatened the life of April Walker or her baby. But yet this manufactured evidence was presented to the grand jury as true. Pitcher describes Phelps' interview methods as terrible. He said he would never interview a witness this way. Yet they presented the statements to the grand jury as truth and not what they really were, manufactured by Phelps to fit her theory of the case. Paula Belamonte was also discussed before the grand jury. And Pitcher told the grand jury that Paula said she was 100% positive that Rory Wilson was the person who committed the crime that night. And she picked him out of a lineup, and she wrote 100% positive next to the picture. What they omitted from the grand jury was that Paula had also told them that Tucker was not involved. During her sworn deposition, she stated numerous times that she was positive he was not involved, that she personally knew him, that she spent over an hour with him the day after the crime was committed, and that the second suspect had a different body style, size and voice. She has continually maintained that she not only told Pitcher this, but she also told Colin Dunn and Christine Poist repeatedly. At her sworn deposition, she was asked, "How many times do you think you told Detective Pitcher that Ty was not the right man, that he was not involved?" Answer, probably around 10. They knew, O'Quinn and Paula personally knew Tucker and maintained that it was not Tucker. They knew Paula, and multiple other witnesses told them that Anthea Clay set the whole thing up. Pitcher knew. He was there. He witnessed it. He saw Anthea Clay return to the crime scene the day after the crime, threaten to physically attack Paula and paint a message to murder victim Matthew Bonnet on the wall of the treehouse. Your Honor, that's a problem, because, as Your Honor recalls, much was made about the misrepresentations made by both Pitcher and Dunn at the Arthur hearing and subsequent hearing about not being able to find Anthea Clay, glossing over Anthea Clay. These photographs of the statement on the wall, although available to the state and known by the state, were not even produced to the defense. If not for the substantial amount of discovery that we conducted in this case, we would have never known about them. The statements say things like double murder on my mind, and, it should have been her and not you. The grand jury heard nothing about Anthea Clay. They talked about Travis Johnson. Pitcher told us at his deposition that he knew he was fed his confession by Phelps. But at the grand jury, Dunn led him. Question: he admitted to you that he was aware that they, meaning Travis, that they were armed when they went to the treehouse? Answer: that is correct. Pitcher knew that was not correct. Travis never told Pitcher that he saw Tucker with a knife. At his deposition, we asked him, John Travis Johnson, says, you never saw Tucker with a knife, correct? Not beforehand, not after, never? Did you ever say you saw Tucker with a knife? That is correct. Never did. He also told us at his deposition that he believed Phelps planted evidence. At the grand jury, he was asked, question: did you find anything? Did you find any masks or anything inside the truck? Answer: yes, we did. Or, excuse me, not yes, we did. A black bandana and several knives in the truck, which were all confiscated. Pitcher told us on page 348 of his deposition that he was so concerned about Phelps allegedly finding these items because they weren't there when he searched the truck. But, suddenly, when Phelps and her select group of subordinates search it days after Pitcher did, they are there. Dunn not only prepared Pitcher and presented the case to the grand jury, but she was also the only person to swear to the information. And the state suggests in their response there's nothing wrong with an attorney preparing a witness. But there is a problem, Your Honor. There's a problem when the meeting is to conspire to present false, misleading and untrue testimony. There's a problem when the witness is told what to say by the attorney. There's a problem when an attorney, who the state knows has lied and concealed evidence in at least one other case, is allowed to meet with a witness before he testifies. And there's also a problem when the attorney has also acted as the investigator in the case and not just an impartial officer of the court. Her unconscionable actions cannot be ignored by the court. The court must evaluate her conduct. She set up the questions. She orchestrated the answers. And the state is responsible for her conduct. The state uses words like conspiracy and personal attacks over and over again in its response to the motion. They are used to minimize the illegal conduct. They want this court to ignore it. They say it's personal. It's a personal attack. Your Honor, I suggest that there is nothing more personal than charging a man with a crime that you know he did not commit. It is the state that has a personal interest in protecting Dunn. The state's been put on notice that the defendant is planning a civil action against it for what they have done to him. They want to chalk it up to a personal attack. But from the Supreme Court of this state down to the sheriff, other courts and investigative agencies have investigated and or reached conclusions about various aspects of this case. The state and its agents have either lost or have been severely sanctioned at every turn by every entity listed on this slide. In this circuit, Judge Koenig, and then the 3rd DCA after the state appealed, agree with Mr. Tucker about perpetuating the testimony of Paula Belamonte. The court, didn't I allow for a deposition to perpetrate testimony of her? Ms. Higgins, yes, Your Honor, but this would be for an upcoming civil case. The court, okay. But it was granted in this case? Ms. Higgins, yes, Your Honor. The court, okay. Ms. Higgins, with regard to the Florida Supreme Court, the Florida Bar has suspended Colleen Dunn from the practice of law not once, but twice now for her conduct in this case and in others. The court, in this case? Ms. Higgins, yes, Your Honor. And the conduct is important. She was suspended in the other case for lying to the court and hiding evidence. And in this case, she was suspended for interfering with this defendant's constitutional rights. The Supreme Court of this state and the Florida Bar do not agree that defense's complaints about Dunn are merely personal attacks or a conspiracy theory. They have found that she has committed acts so serious and so repugnant that they imposed one of the most severe sanctions available to them against her for her blatant ethical misconduct, suspensions and public reprimands. In federal court, Penny Phelps filed a lawsuit against the defendant, the sheriff, myself, and the defendant's wife, alleging that she's the victim here. She filed a lawsuit in federal court alleging defamation and conspiracy. The state's response to this motion parrots what Penny says: she was personally attacked. However, the Honorable Jose Martinez disagreed with Phelps and found summary judgment in favor of all of the defendants. He found that no jury could find any actual malice in anything that defense has said about Penny Phelps. And, Your Honor, we submit that that's because it's all true. The sheriff. Both Captain Penny Phelps and Matthew Pitcher were complained about by the defendant and investigated. The sheriff terminated Phelps for her conduct in this case, the most serious sanctions the sheriff could impose. Pitcher was also disciplined and found to have been guilty of mishandling almost 200 pieces of evidence in this case. The sheriffs investigated and took actions about Phelps conspiring with Dunn to pack the courtroom to try to intimidate the defense. The court, I thought Ms. Phelps was terminated because of a particular statement or series of statements she made to some other officers when pursuing Mr. Wilson, is what I thought the misconduct was for her termination. Ms. Higgins, that's correct, Your Honor, but there were other investigations open at the time when she was terminated. And the sheriff's office's response to the packing the courtroom was to remove her from this case and then pursue an internal affairs investigation. Ultimately, after they terminated her, they closed the other cases. But the sheriffs took action on her packing the courtroom. They removed her from the case and opened an IA file. Now, Your Honor, as we stand here today, where are those officers? Where are the 20-plus officers that we saw that day pack the courtroom? Nobody's here. Nobody wants to stand behind this conduct, Your Honor. Everyone sees the problems here. Why hasn't the state attorney? There are so many misrepresented facts. These are certainly not all of them. It's just a sampling of some of the most egregious. They demonstrate the state attorney has no regard for the law, the oath they take as prosecutors, or the truth. Mr. Ballarotto will go through the law with you, requiring the court to take action by dismissing the indictment and the information to protect this defendant from the state's blatant corruption in this case. Thank you, Your Honor. The court, thank you. Okay. So about 32 minutes left. Mr. Ballarotto, I'm sorry, Your Honor. The court, 32 minutes left in your hour. Mr. Ballarotto, oh, I won't be that long, Judge. The court, I just thought I'd give you a sense of the time. Mr. Ballarotto, I'll tell, you know, Judge, on this Friday, I'm going to tell you what I'm going to do for the court. I'm going to make this easy for you. You know why? I'm going to tell you why, because there's no real dispute. The law, and I'm going to talk about the law in a second. The law is as clear as a bell. No one disagrees with the law. There's no dispute about the law. And, frankly, there's no honest dispute about the facts or the timing of what anybody knew, because the facts that we've presented to you is not even a credibility call with regard to witnesses. Most of what we have shown to you and what I'm going to discuss with you briefly again are facts that were made and statements that were made by Mr. Pitcher in the grand jury, Detective Pitcher in the grand jury, and then statements that he made 2 years later, when he was in a deposition, or statements or texts that were sent by Colleen Dunn to Detective Pitcher contemporaneous with what was going on when he was talking about other witnesses. So there's really very little dispute about the facts and the law. As I said, this is crystal clear. So, you know, what is the issue? Okay. The state attorney oftentimes has said that Pitcher didn't know that he was lying in the grand jury. Pitcher didn't know that he was presenting falsehoods or misrepresentations or omitted material facts when he testified in the grand jury, and that, you know, it's in my mind, you know, it's a hallucination that Dunn and Phelps conspired with Pitcher and with each other to gild the lily of what they put in the grand jury. Well, this is about as basic as the law can get, Judge. All right? No defendant should ever be forced to stand trial and defend against false allegations made by corrupt law enforcement officers. That's one of the reasons why we felt it was so necessary during this presentation and in our papers to discuss with you the prior conduct of individuals, and the police officers, and the prosecutor that was involved in this case. The court, where does this whole, I mean, is there a citation from a case, or is that just your codification of some? Mr. Ballarotto, this is a summary, Judge, of all the cases, of the Anderson case and other cases. And I'll be more specific with you on that right now. For example, the Florida Constitution provides that no person shall be deprived of life, liberty or property without due process of law. Now, you know, as attorneys and Americans, we've heard that phrase a million times in our history. We know what that is. We know that that's the Fourth Amendment of the United States Constitution and the 14th Amendment of the United States Constitution. Okay. And it is also part of the Florida Constitution. The Florida Supreme Court stated, the Florida Supreme Court, in the Anderson case, stated that the state violates this section, that is, the Due Process Clause of the Florida Constitution, when it forces a person to stand trial and defend himself against charges that it knows are based on perjured material evidence. I suggest, Your Honor, that's precisely where we are in this case. The court, you're making some pretty serious accusations against the state attorney's office. Mr. Ballarotto, we are, Judge. The court, you know, that's some very, very serious accusations. Mr. Ballarotto, they are. Judge, you do not have to impress upon me how serious these accusations are. That's, I suggest to you, when I first started, why Colleen, we don't know what else went on in that office. We know that Colleen Dunn stood here and objected at least 3 times, maybe 4, that we should not get these grand jury transcripts. It wasn't until I discussed that matter with Mr. Mansfield that he agreed to give us and not oppose our obtaining the grand jury transcripts. The court, Colleen Dunn is no longer at the office or part of this prosecution team. Mr. Ballarotto, well, that's right, Judge. And maybe if she had behaved in such a manner obtaining this indictment that was the basis for this prosecution and she's no longer there, then dismiss the indictment. It's her. I don't know how to describe the conduct. It's evil. There's no doubt her complete and systemic disregard for the rights of the defendant, for the principles that are contained in our Constitution and the state constitution that brought this prosecution to where we are today. We didn't do this. We didn't present to this grand jury. We didn't put this evidence in the grand jury. We weren't there to defend what they did in the grand jury. The court, presumably, if this goes to trial, you'll be there, and you'll be able to cross-examine witnesses, and do impeachment and present evidence. Right? Mr. Ballarotto, Judge, they are not mutually exclusive rights. Okay. It's an entirely different right based on the law in the state of Florida. They went to the grand jury, and as we've stated here, and I'm going to continue to show you more evidence of that, they obtained an indictment, and Colin Dunn signed the information, knowing that the accusation was false, that it was based on false information that was brought into the grand jury intentionally. As this says, a prosecutor who permits a defendant to be tried upon an indictment which prosecutor knows is based on perjured material testimony without informing the court, opposing counsel, and the grand jury, violates due process, violates the due process clause of the Constitution of the state of Florida and the United States Constitution. And you will notice, Judge, that this is an interesting statement. This is from the Anderson case also, that, it says, a prosecutor who permits a defendant to be tried upon an indictment, okay, which prosecutor knows is based on perjured testimony, there's no time limit on that. I know that the prosecutor has said, well, Pitcher didn't know that what he said in the grand jury wasn't true until some later time. We disagree with that vehemently. But let's just say for a minute that's true. That doesn't relieve the prosecutor. If the prosecutor puts, or the police officer through the prosecutor puts testimony in a grand jury that they learn is not true, the fact that he didn't know that it wasn't true at the time doesn't alleviate them. It doesn't forgive them. It doesn't relieve them from the obligation of going back to the grand jury and fixing it or advising opposing counsel, or the grand jury, or the court, because they are two separate rights. And as you can see, it talks about the time of trial and the time that the grand jury acted. So even the defense that they've asserted, that he didn't know that he was lying, when he found out that what he said wasn't true, they should have gone back. Judge, they had the opportunity to go back. They had the opportunity to go back anytime they wanted, but they have not. Now, the Anderson case. Here's a more full statement of the Anderson case, which I think is important. Anderson, and this is not idle chatter. This is not just, gee, this sounds good. This is the Florida Supreme Court. And it says, due process is violated if a prosecutor commits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court, opposing counsel, and the grand jury. This policy is predicated on the belief that deliberate deception. I suggest to you, Judge, it doesn't make any difference when the deception occurs. If they find out later that it was deceptive when it was presented to the grand jury who returned the indictment, they should have gone back and fixed it. This policy is predicated on the belief that deliberate deception of the court and jury by the presentation of evidence known by the prosecutor to be false involves a corruption of the truth-seeking function of the trial process. The court, what do you mean go back and fix it? I don't know what you mean. Mr. Ballarotto, well, Judge, unlike the defense, the prosecutor can go back to the grand jury anytime they want. They can go back and ask the grand jury to consider a superseding indictment. They can go back to the grand jury and say, we would like you to know that this testimony that was presented to you concerning what Todd O'Quinn said or what Paula Belmonte said was not accurate. We'd like you to reconsider this indictment based on these facts that we know are true and accurate. Is that an unreasonable obligation to seek from a prosecuting authority? I suggest it's not. I suggest it's not, Judge, because, as I've said, the right to go to trial and the right to be indicted before he was facing charges of this nature are not mutually exclusive. You don't get one and not the other. So let me just point this out to you as an aside. We talked about the willingness, the systemic disregard for the Constitution that Colleen Dunn, Assistant State Attorney, had for the rights of the defendant. And this is a perfect example of what she did in this case. During the course of this case, Colleen Dunn, knowing that it was wrong, knowing that it was terribly wrong, took Naheem Jackson and sent him into Ty Tucker's cell and supposedly obtained a confession from him and went ahead and put his name on the witness list, provided it in discovery. And had she not been removed by the Florida Supreme Court, we'd be trying this case with Naheem Jackson testifying. It was a violation of a constitutional principle that's over 100 years old. But she didn't care. It made no difference to her. And this pales in comparison to what she was prepared to do in the grand jury, what she did do in the grand jury. So we filed a motion to suppress the statements by Naheem Jackson for that very reason, because it was a constitutional violation. And these prosecutors, I suggest to you, Judge, they filed a document in which they said they concede the removal of Naheem Jackson. I suggest to you the reason that they conceded to the removal of Naheem Jackson is because it was obviously a constitutional violation, and they wanted no part to defend it. I can't imagine anybody that would want to defend it. It was a blatant disregard for the principles of the Constitution over 100 years old, but Colleen Dunn was prepared to move forward with it. This is another example, and I know Kara touched on it, but let me just briefly restate it again. I don't know how you define perjury, how you define that what you're saying is not true when you go in with the grand jury. But in this situation, look at what April Walker said. You have it there on the right, what he told the grand jury. So he said, oh, well, she said this about Tucker and that about Tucker, and he was going to kill her baby and kill her, and that he was too smart, all the stuff that's listed there. But what really was the truth? He admitted 2 years later, maybe more than 2 years later, under oath at his deposition, oh, yeah. Actually, that came from Captain Phelps' mouth and were just parroted back to her by April Walker. The court, well, again, playing a devil's advocate, isn't that like an attorney asking a witness a leading question? Mr. Ballarotto, yeah. Sure, Judge. That's right. And if an attorney asks a witness a leading question and it's not true, when a witness is on the witness stand, they have an obligation to point that out. The court, yeah. That's not true. Mr. Ballarotto, absolutely, but he didn't say, here's what he said was true. Okay. And, frankly, it's not even a leading question. It was a narrative that was given by Pitcher. But when he gets under oath, when he's giving the deposition, he admitted that there was no evidence that Ty Tucker ever threatened the life of April Walker or her baby. Yet he made those statements that led the grand jury to believe that that's what April Walker said. The court, what part of this 6 paragraphs are you referring to? Mr. Ballarotto, well, all of it was just page 69, line 22. That's what Pitcher said to the grand jury. He said that April Walker said that Ty said, I'm the one who set your husband up. I'm free. I'm sick not. I was able to lie my way out of this. That's why I'm free and he is not. If the police come here, I will know you called, and I will come look for you and your baby. This is what he said April Walker said. When he testifies under oath in the deposition, he says, those were merely words parroted back to her from Penny Phelps, and that he knew that there was no real evidence that Ty did any of that. Those were Penny Phelps' words that she put in the mouth of April Walker. But he didn't say anything like that. Just like when he testified to the grand jury, he never said that he knew that there was no probable cause to indict Ty Tucker. That's based on the actual statements made by Detective Pitcher. So one more, Todd O'Quinn. This, Judge, I think is one of the most egregious. Okay. And I'm going to tell you why. It's most egregious because of the timing and the selection of questions by Dunn, and it's extremely probative. Okay. So during the course of his testimony, he told the grand jury that O'Quinn saw a man run from the tree house with his mask and he could tell he was white. Let's look at that question. All right? She says, talking about at the point when he runs away, the question by Colleen Dunn, tell the members of the jury, what does he see leaving the tree house? A wide open question. And so Pitcher says, so as he goes over to the CVS area and he looks back, he sees a subject running out of the front gate of the tree house and turning what should be to his right. And then she asked him to step down and do an diagram. And then she asked this question, okay. And does he, meaning Todd O'Quinn, does he say he notices anything about the suspect? And Pitcher says, he said he sees the subject lift his mask, and then he can tell it's a white man. But Todd O'Quinn also told Pitcher that's no Ty Tucker, and it was definitely not Ty Tucker. The court, where did that come from? Mr. Ballarotto, it's in his grand jury testimony. The court, where does it come from that O'Quinn said it was not Tucker? Mr. Ballarotto, in an interview with Pitcher. And Pitcher was asked about that, in which he says that on more than one occasion, he says, by January of 2019, how many times had Todd O'Quinn told you that it was not Franklin Tucker? How many times? And he says, I don't know, here's what he says, I don't know. He said that this person was wearing a mask, and he did not get a look at their face because they started to pull the mask because they were running away from him. Question, didn't he also tell you that he knew it wasn't Ty Tucker because he knew Ty Tucker? Answer, he said he didn't think it was Ty. Yes. He did not believe it was Ty Tucker. And he told you that? Yes. The court, he didn't think it was. He didn't believe it was. That's not quite as emphatic as your words say there. Mr. Ballarotto, how is that any different? The court, I don't believe it was, I don't think it was, those are somewhat equivocal, but, Mr. Ballarotto, I don't think that's equivocal at all, Judge, because here's what he said. He said he knew Ty Tucker, and you'll see. It. There's more details in our papers because we don't want to go over everything we filed in our papers. But he knew Ty Tucker, and he knew that it wasn't Ty Tucker. And he said, okay. I believe it wasn't Ty Tucker. Is that what you get from this? Is that what the grand jury was led to believe here? He doesn't say anything about Ty Tucker. All he says is it was white male, leading the grand jury to think that all the information we have was it was a white male, but that's just not true. And what I'd like to know is, how in the world does Colleen ask that question knowing that Pitcher is not going to say that O'Quinn told him that it wasn't Ty Tucker? How does that happen? There's only one way that happens, Judge, and that's the conspiracy. That's where, the court, what would be her motivation? I mean, she's so bloodthirsty, figuratively speaking? Mr. Mansfield, that's a good question, Judge. And I'm going to tell you why you'll never know that answer, because you can't get into the brain what Colleen Dunn was thinking. You've seen how many times she's disregarded the Constitution, how many times she disregarded defendants' rights, how many times she made representations that were not true. You can't use your sensibility, your sense of right and wrong, your belief in the Constitution, your respect for the law and try to understand what she did. You can't do it. All you can do is decide that what she did was wrong and she shouldn't have done it. This is a good example. Pitcher tells the grand jury, okay. And does he say he notices anything about the suspect? This is the question. This is Todd O'Quinn. And he said he sees the suspect with his mask and that he can tell it's a white male. Now, as a reaction to Pitcher's interview of O'Quinn, she sends him a text. She sends him a text on March 14, 18, after he interviews Todd O'Quinn. What does she say? Still says it was not Tucker? Still says it was not Tucker? That's Colleen. That's right out of her mouth. How conclusive can that be? And you know what? They did the same thing with Paula Belmonte. They talk about Paula Belmonte. They showed her. Oh, and by the way, they never told the grand jury that they showed a photo spread. They showed a photo spread to Todd O'Quinn that had Tucker's picture in it. Okay. And he said that the person in the photo spread looked most like the man that committed the offense was Travis Johnson, not Ty Tucker. It was definitely not Ty Tucker. He knew Ty Tucker, and Ty Tucker was not involved in these crimes. And they did the same thing with Paula Belmonte. Paula Belmonte, they testified how they showed her a photo spread and she completely absolutely identified Rory Wilson. Okay. That's good. You saw what we showed you just a few minutes ago. She testified at her deposition, a statement of a victim now who said, 10 times, she told Pitcher, it definitely was not Ty Tucker. The other guy was definitely not Ty Tucker. She knew his body style. The guy was heavier. It was a different body style, and it was definitely not Ty Tucker. How do you not put that in the grand jury? And it gets compounded because we now have 2 of the victims who survived, 2 of the people who survived this, O'Quinn and Tucker, O'Quinn and Paula Belmonte. Todd O'Quinn and Paula Belmonte, the 2 people who survived, both say it wasn't Ty Tucker, and that doesn't get before the grand jury that's considering a life penalty, a life felony on a person? So as I said, how did all this happen? It all happens, I suggest, Your Honor, through a conspiracy. There's no way that Colleen Dunn would ask these questions and not know that she had already discussed it with Pitcher, that he was not going to provide the information that she did not want to be provided. Well, I've said pretty much all I have to say, Judge. I said to you before that they never went back to the grand jury. I think they really had an obligation, no matter how you roll this, to go back to the grand jury. That's a sacred body, the grand jury. It really is, Judge. It's 23 people that give up their lives and are supposed to take an honest look. And in situations like that, you know, they are the first line of the preservation of the defendant's rights to be sure that there is no unethical prosecutor like Colleen Dunn running off, charging somebody without sufficient evidence. And look where we are today. All the scientific evidence, all the DNA, all the blood, everything else, nothing came back to Ty Tucker, not a thing. Okay. The court, okay. I don't know that. Mr. Ballarotto, I can make that representation to you, Judge, that there's no scientific evidence. There's no DNA that connects Ty Tucker to anything they found. There's no blood. If I am not telling you the truth, I'm sure they will. The court, well, I'm sure that, as an officer of the court, you're representing true statements there. I'm just saying that, you know, I've taken Johnson's plea, I've presided over the trial on Wilson, but I don't know the precise state of evidence as far as your client is concerned. Mr. Ballarotto, okay. This is what the Anderson case said, Judge. I'm just going to put it up for one last time, because it's so compelling, and it's so clear as to what the obligations of a prosecutor are and what the defendant should not have to suffer. Okay. And I suggest to Your Honor that there's every reason to believe that there was some agreement, some conspiracy, or some understanding that was going on between what Colleen Dunn was asking Detective Pitcher in the grand jury and the answers that he was giving. There's no way she would have gotten incomplete, inaccurate answers unless she knew that those were the answers that were coming. When she says to Pitcher, when she asked about Todd O'Quinn, well, what did he observe? What did he say he saw? And Pitcher says, he just saw that he was a white guy. Why wouldn't she follow it up and say, well, did he tell you that when he saw the person, he knew that it wasn't Todd O'Quinn, he didn't believe it? Was Todd O'Quinn, he knew Todd O'Quinn, and he didn't believe it was Todd O'Quinn? Why wouldn't she ask that question? There's only one reason why, because she didn't want the jury to know. I suggest to your honor that, while, as sad as it is, that we need to stand here and make these arguments, and attack a member of the bar, and make these statements concerning her conduct in the grand jury and her disregard for the defendant's constitutional rights, they are well deserved, Judge. And under these circumstances, the only alternative that we have, there's no one else for us to turn to. You're the only person that we can turn to, the only one that can do this. The court, let me ask a few questions if you're finished. Mr. Ballarotto, sure. Does this count against my time? The court, yes. I gave you more time than you've been allotted. What's the standard? And I know the answer, but just help me understand the remedy you're seeking, for that grand jury. That's a pretty low standard to issue an indictment, isn't it? Mr. Ballarotto, I know what the standard is. The standard is probable cause. The court, right. Mr. Ballarotto, and probable cause is described as a scintilla more than mere suspicion. The court, that's a pretty low standard. Mr. Ballarotto, it is a low standard. The court, and so then we go to the Arthur hearing. And I realize that a lot of things have happened since then and that you undoubtedly disagree, in all due respect, with the decision I made, but I found strong proof without parroting the standard. And so I mentioned during this hearing here that you still have all of your client still has all the rights of confrontation, cross-examination, impeachment, proof beyond a reasonable doubt. So what's the remedy you're asking for here? Mr. Ballarotto, the remedy we're asking for is, Ms. Higgins was just reminding me that whole Jackson incident with a confession by the paid informant in violation of the Constitution was presented to you at the time of the argument. The court, yes. That's true. That all came up at that time. Ms. Higgins, Your Honor, if I may, if the court allows me? The court, real quickly here. Ms. Higgins, Your Honor was also shown a video of allegedly that night that Detective Pitcher told us later he cannot verify was actually at the same time, taken at the same time, and that it did not show what he testified to. He was given a script before the Arthur hearing by Colin Dunn, a written supposed to say. And you were presented with many facts at that Arthur hearing that are absolutely not true. And, Your Honor, at that hearing, you asked about Anthea Clay. The court, I asked about Ms. Higgins. The court, I asked about, Ms. Higgins, you asked about Anathea Clay. You said, I've heard this Anathea Clay. Who is Anathea Clay, and did you go and talk to her? That's when you were directly lied to by Colleen and Pitcher when they told you that they couldn't find her, that they would like nothing more than to find her, and they couldn't. She was exactly in the same place as she was the night of the crime that we found. So, Your Honor, you were not presented with accurate evidence at that Arthur hearing. And as the court recalls, after all this came out in our discovery, the state agreed for bond for Mr. Tucker. The court, yeah. I recall. Thank you. So, anyway, we were getting to the remedy here. Mr. Ballarotto, yeah. In response to your question, Judge, you know, I just want to point out to you that when the Florida Supreme Court in the Anderson case discussed this issue, the defendant in that case was in the same situation. And they didn't say, oh, well, you know, it's harmless error. We can deal with it at trial. There's more at stake here than Ty Tucker. This is bigger than me, you, Ty Tucker, Mr. Mansfield and Ms. Courts, and even Ms. Higgins. This is a bigger issue, Judge. This is the kind of behavior that can't be tolerated. This is the kind of behavior that the court needs to protect. A grand jury is an integral part of our judicial system under all circumstances. So you don't see the state Supreme Court saying, oh, yeah. That's okay. They can go to trial. They can cross-examine witnesses. We don't care what they did in the grand jury. It's no big deal. That's not what they said. The court, so it's like punitive damages, in a rough comparison, that the conduct was so egregious that there has to be some sort of sanction that will deter this in the future? Mr. Ballarotto, you do that all the time, Judge, don't you? Isn't that the policy of the court? The court has to say, listen, I am not going to stand here and conduct a trial of allegations that I believe were insufficiently brought, that they were brought as the result of false statements, incomplete statements, intentional misgivings in front of the grand jury. You know, there are remedies. If they want to go back to the grand jury without all of this stuff that Colleen Dunn did, they can do that. Let's see what happens. They may very well return no bill based on the evidence that they really have now. And that's the remedy. The remedy is say to the state, you know, I'm not going to let you try this man on an indictment which was brought under these circumstances by this person who has no credibility. The court, so you're saying it's not a dismissal with prejudice? That if they somehow or other, if the court made this ruling, that they could go back and start over again? Mr. Ballarotto, that's your decision, Judge. The court, well, Mr. Ballarotto, you could. You could say it's with prejudice, and then forever the prosecution will be barred. Forever it will be barred. You can't say that, I am not going to permit this to go ahead. I will dismiss it without prejudice, and see what the state does. See what the state does with the real evidence that they have. The court, okay. Thank you. Mr. Ballarotto, I guess I didn't make it as easy as, the court, I didn't. When you said easy, I usually have a response. But I'll say it now. Usually, 99% of the time, when an attorney says, this is going to be simple, Judge. This is going to be easy, that's a red flag that tells me it's anything but. So you've certainly maintained the sanctity of that rule, but it's okay because I didn't expect it to be easy. There's nothing easy about this case. Mr. Ballarotto, not from the very beginning. Thank you, Your Honor. The court, thank you. You've got about 3 minutes left. State. Mr. Mansfield, Judge, thank you. The court, and just so I'm clear, the defense has filed a motion, the state has filed its response, and then the defense has filed some sort of reply? Counsel, you filed a reply, right? Mr. Ballarotto, I'm sorry? The court, you filed your motion, Mr. Ballarotto, yes, Judge. We filed a motion, they filed a response, and we filed a reply. The court, all right. Okay. So let's hear what the state has to say. Mr. Mansfield, Judge, good afternoon. First of all, we're going to be splitting our time, Judge. I'm going to talk a little bit about the factual misrepresentations, and then Ms. Courts will come up and talk about the law. Judge, as we sit here, I understand Colleen Dunn has been made out to be the two-headed dragon, and everything is Colleen Dunn. She's dirty, deceivious, unethical. You name it. I get it. That's the popular argument to make because Colleen Dunn had an issue with the bar. She was sanctioned for it. She served her sanction for it. In this case, Colleen Dunn did nothing wrong. The court, well, I just heard from Ms. Higgins say that she was sanctioned for something she did in this case. Mr. Mansfield, not to my knowledge, Judge. The court, well, I don't know. I asked Ms. Higgins directly. I mean, that was news to me, but she said she was. Ms. Higgins, yes, Your Honor. And it was for interfering with this defendant's constitutional right to marry his wife. That is part of the second suspension by the Florida bar. I'm surprised to hear this from Mr. Mansfield because we have discussed it. But she was absolutely sanctioned a second time. And as we sit here today, she is still suspended from the practice of law. She is not a member of the bar. and this has been resolved. The court, okay. So that was the whole marriage issue. Mr. Mansfield, yes, Judge, and I apologize. I didn't know about that. I didn't connect that to be integrally involved in this case. There was a text message where she articulated she wanted to block the marriage somehow, I guess. I don't know. But as far as the court, I remember. Mr. Mansfield, the behavior in this case, I didn't connect it. Ms. Higgins, yes, Your Honor. The bar conducted an investigation. She's suspended. The Supreme Court of this state has approved it. She's been suspended twice. The court, okay. Ms. Higgins, thank you, Your Honor. Mr. Mansfield, so, Judge, so taking you back, this case came in November of 17. This case went to the grand jury approximately 1 month after the event. 1 month, they were in front of a grand jury. Ms. Dunn presented one witness, Detective Pitcher, at the grand jury presentation, 1 month after this stabbing occurred at the Tree House. The grand jury is, Your Honor went into it just recently, their finding is a probable cause finding. So when the state went in for that grand jury presentation, they knew what they had to meet was a probable cause determination, not proof evident, presumption great, not even proof beyond a reasonable doubt. Probable cause. Quite frankly, Judge, probable cause is met by the testimony of Travis Johnson. Travis Johnson is the one witness in this case who had stayed true to his initial statement all the way through. From the day he was interrogated by the police officers to the day he testified in Rory Wilson's trial, his story has never fundamentally or materially vacillated. He lays out the entire plan, who participated in it, and that is the story that he gave from the very beginning. So, quite frankly, this case goes to a jury based on Travis Johnson's testimony alone, because if a reasonable person believes his testimony, then Franklin Tucker's guilty. Now, at the grand jury, they presented Detective Pitcher, and he briefed the grand jury on these various players. And I just want to go into some of the particulars that is worthy of pointing out to this court. Let's start with this Todd O'Quinn. First of all, Todd O'Quinn initially says, on the night of the crime, he couldn't identify but only saw someone running away, lift up the mask only long enough to identify the person as being white. It was also obvious that O'Quinn was under the influence of something on the night of the crime. At some point, he's shown a lineup, and he essentially is told to point out anybody in this lineup that is related to the crime or anybody that he recognizes. He did not point out Tucker as somebody he recognized. At a later time, O'Quinn came back and stated, "Oh, I do recognize Tucker, but it wasn't him," at a later time, after the grand jury presentation. So his initial story is, I don't see anybody in there that I recognize that's related. Oh, wait a minute. I recognized Tucker. I know Tucker, and he wasn't involved. I submit to you that's not reliable in any way, shape or form one way or the other. Am I going to call him to trial if we get to trial? Probably not. Todd O'Quinn also says Travis, he doesn't say Travis looked most like the suspect. What he said was, of all the people in the lineup, his hair looked most like the person's hair, the person who lifted up their mask. So he initially says he can't identify the person, and then all of a sudden, he says, oh, and he never pointed anybody out that he could identify or was even familiar with him. Later on, he points out, oh, wait a minute. I do know Tucker, and it wasn't him. His story starts out that he did not know Tucker. He only knew Wilson. That's the beginning of his statement. And later on, now, of course, he's known Tucker for years, and he met Tucker when they were both in the Marathon jail a few years back. Let's talk about Paula Belamonte. Detective Pitcher was presented an overview of Paula Belamonte's testimony to the grand jury 1 month after the stabbing. At the time of the grand jury presentation, Paula Belamonte was not saying that it was not Tucker. Paula said she did not get a good look at the second suspect. She could only state that the second suspect was smaller and shorter than Detroit, Detroit being the name she knew Rory Wilson to go by. Her deposition was over a year later after, well over a year after the grand jury presentation. That's when she starts saying, it's not Tucker. Oh, I know Tucker. It wasn't Tucker. It wasn't Tucker. Didn't say that in the early days of the investigation. The only thing she was talking about was that Wilson had attacked her. And, Judge, I think it stands to note that Paula Belamonte was homeless, living in this structure that had no water and no electricity with significant and multiple health issues. But, somehow, a year later, she hires a private lawyer, a local private lawyer to represent her, not court-appointed. This homeless woman, who is living in the tree house with no running water, no electricity, hired a lawyer in town to represent her. Let's talk about Rory Wilson. There was much made about, not today so much, but much made about this missing portion that Colin Dunn had hidden from Rory Wilson's interrogation. There was a problem with one of the tapes, and there was a portion missing. But that portion was picked up by a body-worn camera in the room at the time, and that was turned over. So at the end of the day, there was nothing hidden, nothing secretive, nothing excised, nothing edited from that interview. It makes for a good press, and it makes for a great slam on Colin Dunn. But the bottom line is, the body-worn camera picked up the entirety of that interview, and there was no collusive activity on her part. During the presentation to the grand jury, the subject of Anthea Clay came up. Pitcher explains later on, over a year later when he did his deposition, about the steps he took to find Anthea Clay. There was never any evidence that anybody was intentionally hiding Anthea Clay or getting her out of town so that she would not be available. In fact, she left the county for a while. But, again, her unavailability that Pitcher articulated was over a year later at his deposition. There was allegations that April Walker had been coached by Pitcher. And Pitcher's statements in his deposition, again, years later, Pitcher never said she was coached. What Pitcher said and articulated very specifically, and, Judge, as I said before, I am a student of the text means something. Antonin Scalia lives inside my mind. So he says in the depot Mr. Tucker denied April's story about him changing in the storeroom, right? Because there was an allegation that April had seen Tucker changing and had given her a sign that, if she said anything about what she was seeing, that harm would come to her and her baby. Pitcher responded, that is correct. And then the question was, you believe that Penny Phelps concocted that, right? His answer, no. I believe it happened. Oh, you believed it happened? Yes. Didn't you just tell us that you believed Penny told April what to say? I believe she helped her say the right thing and not lie, like, don't over-embellish or anything like that. That is not an admitting of a belief that Penny Phelps coached her to say something. That's quite the opposite. Words are important. And, quite frankly, Judge, when counsel gets up and argues, well, Matt Pitcher didn't think he should have been arrested for this, who cares what Matt Pitcher thinks? It's his opinion. On all these investigations, Judge, I don't think it comes to a shock to the court that you get a room full of 10 people, not everybody agrees on everything. So Matt Pitcher may have had a personal belief about what he felt the evidence was. Quite frankly, Your Honor, I don't care about Matt Pitcher's opinion. That's why when a police officer makes an arrest, it comes to the state attorney's office, and we investigate the case, and we determine what we want to charge. I don't think in my 25 years I've ever called the officer to say, listen, where do you stand on this? I want your opinion, because his opinion doesn't matter to me. I'm the one that has to prove the case in front of a jury. So Matt Pitcher's opinion, I don't know why that should carry any weight in this courtroom. It's certainly not admissible in front of a jury. If I ask Matt Pitcher, do you think the defendant's guilty, the objections would be so loud, I'd probably go deaf in that ear, because Matt Pitcher's opinion is not relevant. And the objection would be screamed, we don't want the jury to hear that he thinks he's guilty. But now we want Your Honor to somehow record this observation that Matt Pitcher doesn't think the defendant is guilty. So I guess, in trial, they're not going to object if I elicit that question at trial. So the opinion question, I guess, is self-serving. It depends on what the opinion is. Travis Johnson. Travis Johnson, that's the one. Travis Johnson has been consistent from the get-go, and the grand jury heard all about Travis Johnson's statement. To this day, that is Travis Johnson's story of what happened, and it fits the evidence in this case. Defense wants to say Naheem Jackson, oh, the state even agreed to the motion to suppress. Judge, there's something called strategy. The state decided not to use Naheem Jackson as a witness. Unless the court asks me, I'm not going to go into the reasons why. That is a strategy decision that the state made. It is by no means us conceding that we think that some illicit behavior was done there. I'm not conceding any wrongdoing. I'm simply saying, before we launched into defending him in a motion to suppress, our evaluation was, you know what? Let's not waste time on this. Let's concede. We're not going to call him anyhow, so strike him from the witness list. Don't want him. Don't find him to be of any value. The court, okay. I mean, there was, before your employment with the local state attorney's office, that whole Jackson thing was a big controversy and a big issue as to whether he was really planted and was acting under the, under the guidance of law enforcement or whether this was just somehow or other something that happened as an accident. Mr. Mansfield, correct, Judge, and I understand that. But my point is, instead of saying the state even agreed to suppress the statements, and it says here it was not because we thought there was any impropriety. We just again, quite frankly, I don't want a jury to hear about all of that and go down a rabbit hole that I don't think is going to give any value. The court, okay. Mr. Mansfield, so we went that route. Judge, we released these grand jury transcripts because of our interest in full transparency here. We want to bring this case to trial. I'm asking this court that, after a ruling is made today, to please give me a trial date. This case needs to go to a jury and be done. We are coming up on the 6th anniversary. I was a young man when this happened-ish. So we are asking for a date to get this case expedited. We felt that if we turn over these grand jury transcripts, that will close down a lot of prolonged litigation and problematic litigation that is going to delay this case until you and I are both retired. So, in hindsight, I probably wouldn't do it. But that was our intention at the time because that's where we thought we were going with this. So, at the end of the day, going back to this grand jury presentation, which is the heart and soul of what we're here for today, was their perjured testimony intentional testimony put forth in front of the grand jury to mislead them? And I submit to your honor, there's been no evidence of that. Paula Belmonte's changed story a year later, first of all, was not known at the time, 1 month after the stabbing. And, again, I think it's highly suspect, the changing stories of Todd O'Quinn, the changing story of Paula Belmonte, Anthea Clay, here today, gone tomorrow, April Walker. Unfortunately, these are the witnesses that are given to us in this case, and the state presented what they had at that time to the grand jury. The law requires the state to address any material changes in the case, and it's not a material change. Paula Belmonte never identified the defendant in the first place. She said she couldn't identify the second person. So there's no material change. It's one thing if she had fingered Ty, Franklin Tucker, and then later on said it wasn't him. That's material. But she never said it was him in the first place. This court has to focus on, I believe, the timing, the timeline, and the materiality of what the defense says are these grotesque and intentional unethical misrepresentations on Mr. Tucker. And with that, Judge, I'd like to turn it over to Ms. Court so she can brief the court. The court, all right. But before you go, I've got to address a couple of points. Mr. Mansfield, okay. The court, first of all, as you know, a trial date depends upon the determination of this motion. Obviously, if I were to grant it, then, Mr. Mansfield, no. You're right, Judge. Well, can I just clarify something? The court, yeah. Mr. Mansfield, that's only for the murder charged by indictment. All the other charges, the robbery and everything, are by information. So there's still a case. It's just I believe this to be the truth. It would only be the homicide charge, the felony murder charge that would be compromised by that ruling. And, again, the state, I suppose, could take it back to a grand jury if the court puts us in a position where we thought we needed to do that. The court, okay. Well, that's a good point. Your position would be, even if the defense prevailed, that somehow the charges, other than the homicide, could go forward? Mr. Mansfield, I believe so, Judge. And I have to say, these thoughts occurred to me, the court, I don't know. Mr. Tucker, one keep hearing background noise. Maybe it's just by accident, but it seems to be every time there's a point that you don't agree with that I hear something. So whether that's true or not, I don't know. But please be mindful that I can hear certain responses, so please avoid that. The defendant, I'm sorry, Your Honor. I'll try to make sure I'll keep it quiet. The court, thank you. Mr. Mansfield, and it occurred to me, well, wait a minute, only the homicide charge was by indictment. The other stuff was charged by information. I guess that's the way it was done. That's not how I've ever done it. But I believe that's accurate. I can check the court file. So I believe that if Your Honor did grant this motion, I think this only addresses the grand jury indictment, I believe, is what we're talking about today. The court, okay. Well, we'll hear what the defense says about that after we finish with the state's initial argument. The second thing is, I'm painfully aware of the fact that this is a very old case. And, ideally, that's something I try to avoid. But it's not as though we've been idle for the last number of years. As you know, there was a severance, and we've already had a full 12-member jury trial in one co-defendant's case. We've already had a negotiated resolution in the other. And we've had lots and lots of serious litigation about a whole plethora of issues. So while I'm, as I said, painfully aware of the fact that this case has been around longer than I would like, it's not because we haven't been industrious. Mr. Mansfield, no, Judge, and I didn't mean to suggest otherwise. The court, I know you weren't. I just want, Mr. Mansfield, to be clear. I understand. Judge, Ms. Courts just handed me the defense motion. So it does say at the top motion to dismiss indictment and information. So I guess it is an all-or-nothing proposition. Judge, the other thing I do want to make, I got time. So one other argument I believe defense, I've seen this in the pleadings somewhere, well, the state didn't really have Travis Johnson's testimony until we put him in a deal, until we put him in an agreement, a contract to testify, so that by presenting him to the grand jury, we didn't really have his testimony available for trial because that didn't happen until much later. And, again, I submit to the court that that is incorrect, because under a statement against penal interest, it's a hearsay exception, and I believe that that statement would come in under that hearsay exception. It fits all the parameters of that exception that a statement against penal interest would come in. So even if he wasn't cooperating and wasn't testifying, the state still believes they have the benefit of that statement under the rules of evidence. I put it in my phone so I'd have it, 90.804, and I think it's subsection C, or, let's see, hearsay. Exceptions. There it is under subsection 2. But at any rate, Judge, it's our belief that even before a deal was made with Mr. Johnson, at the grand jury presentation, it was presented to the grand jury with a true belief that we had that evidence regardless of what happens with Mr. Johnson, because that statement is coming in. I just wanted to throw that in as argument. I know Your Honor had some other questions for me. The court, no. You covered it. Mr. Mansfield, wonderful, Judge. So I'll turn it over to Ms. Courts for a little legal discussion. The court, all right. Thank you. Ms. Courts, thank you, Your Honor, and I will try to be as brief as possible. Mr. Mansfield did mention, and it caught my ear, that the indictment, essentially the grand jury transcript, is the heart and soul of the issue that we're here for. And the truth is that it's a very narrow issue that the court is called upon to decide in this motion. Should the indictment stand, or should it be dismissed because it was obtained by the use of perjured statements made by Mitt Pitcher? Now, perjury has a very specific definition under Florida law. It's a false statement. The assumption there being that it is a statement that's made, an actual declaration, that the declarant does not believe to be true, and it's under oath. So by its very definition, perjury does not include an omission. That is an expansion that the defense is, obviously, asking the court to make the definition of perjury, but that's not the definition of perjury under Florida law. It requires an affirmative declaration. An affirmative statement made by the declarant that the declarant knows to be false, but he makes it anyway and it's under oath. So there's two issues for the court to consider. Is the statement under oath false? Is it material? And what's the timing of that statement? Materiality, obviously, is a question of law for the court to decide. But I think that those issues have been vetted more than adequately, and I'm not going to beat the proverbial dead horse. An equivocal statement made by any of these witnesses that was then relayed to the grand jury by Mitt Pitcher, that statement later became unequivocal and it wasn't Ty Tucker, isn't material to the fact that the jury found probable cause based on Travis Johnson's testimony. The only person whose testimony was presented or whose statement was presented that, in fact, lays out the plan, who went into the treehouse, who came out of the treehouse, and who was involved is that of Travis. And his story has not changed in any material respect from the time that he was interrogated by the police to the time that he testified at Rory Wilson's trial. Are there variations? Could he have at some point minimized his involvement? Very possible. Does it mean that those issues are material and that they somehow or another detract or undermine the underpinnings of the finding of probable cause by the jury? The Anderson case that the defense is relying upon actually speaks to that, and in many respects is very similar. The co-defendant, the witness's testimony in that case, the girlfriend of the defendant, changed her own involvement in the murder that this person was accused of, Anderson was accused of, several times, at some points completely minimizing her role, at some points saying that she was an actual eyewitness to the homicide. And the court there found that it was not material change in the testimony because the accusation always remained the same. Analogous to the case that's in front of Your Honor, these witnesses never identified anybody other than Detroit, or Rory Wilson, so that they later, 6 months, a year, 2 years down the line, and who knows what's happened in those intervening 2 years. I would hesitate to speculate as to what the conditions were under which they decided that they were going to make a now unequivocal statement that it wasn't this defendant, but it's not material because their identifications were never presented to the grand jury as this defendant was identified by these people as having participated in this crime. And the timing of those statements and their materiality, which I've already covered, negates the argument that somehow or another there was an affirmative statement by Mitt Pitcher elicited deliberately by Ms. Dunn that misled the grand jury into a finding of probable cause and returned the true bill. And remember that the timing of the deposition was in March of 2021, but the grand jury was impaneled and convened and heard this case. This case was presented in 2019, so we're talking about 2 years. I'd also point the court to the progeny of cases that follow Anderson. And I'd cite specifically to Murray v. State, cited at 303D 1108 at page 118, a grand jury is only called upon to find probable cause. That's it, a mere accusation that is sufficient for a petty jury to try the defendant on this case. They are mere allegations, and the allegations are sufficient for the defendant to stand trial. It's not proof beyond a reasonable doubt. It's not proof evident, presumption great. It's merely probable cause. What may have happened subsequent to, which, again, the state's position is that it's not material. But the information that was learned subsequent to the presentation of this case to the grand jury is irrelevant to whether or not the grand jury had sufficient evidence to find probable cause. And I also submit to the court that, again, cited in Anderson is the Jones case, and I apologize. I don't have the cite, but it is cited in Anderson, that the court cannot go behind the grand jury's reasoning. In other words, it's not the court's job at this juncture to opine as to the credibility of the witnesses or the sufficiency of the evidence, only as to whether or not the technicalities of the true bill were met. And, again, I hesitate to repeat myself, but I do think that it bears repeating, it's a finding of probable cause. Any variations in testimony, any potential impeachment material, that is what discovery is for. That is what the rules of impeachment allow. that is for the petty jury to decide once they've been sat as the jurors impaneled to try this case if the court rules in the state's favor, and I urge that you do, to reconcile these potential discrepancies and to make a final judgment of either guilty beyond a reasonable doubt or not guilty, as the case may be. But at this juncture, even if the trial testimony in the court's wildest imagination could go completely differently than what was presented to the grand jury, that's really not a reason to dismiss the indictment. Again, there is no affirmative statement made by Mitt Pitcher or elicited by Ms. Dunn that is perjured under Florida law. And there is no case in the entirety of the case law that I've been able to find, and I've been at this for a couple of weeks now, that suggests that the state is obligated to present evidence that does not support its, well, no. Let me correct myself before I go there. There's no case law that suggests that omissions that are not material, that we have an obligation to present. So, again, I remind the court, this is a finding of probable cause. Anything that may have happened, any behavior by former members of the state attorney's office that the defense has pointed out, anything that happened at the Arthur hearing, anything that's happened subsequent to really, we're not here to argue that. It's a very narrow issue, should or should not this indictment stand. And our position is that it should. Both the indictment and the information should stand, and we urge the court to find in our favor and set a trial date. Thank you, Your Honor. The court, all right. Thank you. Mr. Ballarotto, Judge, may I just have 5 minutes? The court, if you would like to have 5 minutes, we'll allow for rebuttal. Mr. Ballarotto, Judge, can I just have 2 minutes? The court, yes. If you would like to have 5 minutes, we'll allow for rebuttal. Mr. Ballarotto, Judge, we're not going to get into an argument about the facts of what happened when all that's contained in our briefs, and we have citations as to when and how it happened. But I suggest, Your Honor, that it's my recollection that Paula Belmonte met with Ty Tucker the day after the incident at the McDonald's. And immediately after that, she told, it was long before the grand jury was convened, that it was not Ty Tucker. And it's also my recollection that long before the grand jury was convened, the interview of Tyrone was taken, and he said it wasn't Ty Tucker, the person that he saw come running out of the treehouse. And also a photo spread was shown to him, in which he said that Ty Tucker was not involved. So, you know, you're just going to have to, I guess, rely on what's in the briefs, Judge, and see when it really did happen. But there's really a more important issue here that I think needs to be addressed, and that's a legal issue. You see this quote from the Anderson case, and I just pray Your Honor take a look at that case very carefully, because this case is entirely different than what the government is relying on. The government is looking at cases in which the court is asked to evaluate the legality of a search warrant. And they are saying that, okay. Well, these cases say that if you excise the parts of the affidavit to the search warrant that the court finds to be improper or not accurate, the court can then look at the remainder of the search warrant to decide whether there's probable cause. This whole probable cause issue that, frankly, was raised by Your Honor and by the state, who responded to our motion, is a red herring. And I'll tell you why. If you read the Anderson case, do you see anywhere in the guidance directed by the state Supreme Court that if there's probable cause in the grand jury presentation, aside from what was decided was a misrepresentation or false statement, that the grand jury should continue, and the case should go to trial? That's not what it says. It is a bright line test. As it's right in front of you, Judge, on the screen, due process is violated if a prosecutor permits a defendant to be tried upon an indictment which he knows is based on perjured testimony, material testimony. It's not a re-evaluation of what's left. Your Honor, frankly, Judge, even though, you know, you're a sworn judge of our state, you don't have the authority to do that. This is not re-evaluating a decision made by another judge. You cannot re-evaluate the decision made by the grand jury. The state Supreme Court is absolutely clear on this issue, and that if you find that there was a falsehood or perjured testimony or a material misrepresentation made in the grand jury, that's the end of the evaluation, and the indictment is dismissed. That's the law. Dismissed. That's the law. And I'd ask Your Honor to consider that when you're evaluating this case, because if you find that there was any misrepresentation or false misrepresentation and whether or not they were intentionally made at the time, there's plenty of evidence to do that, but there's even more evidence that there was information that was obtained by the state after they put this information in, knowing that it was false testimony and false representations, and they didn't go back and correct it with the grand jury, when they didn't do any one of the options that the state Supreme Court has given them, and that is by informing the court, informing opposing counsel and the grand jury. This is red-letter law. This is not advisory. This is the state Supreme Court. Thank you, Your Honor. The court, thank you. Would the state like to have any rebuttal? Ms. Cortez, nothing further from the state, Your Honor. We've already made our argument. The court, okay. So let me ask this, when are we next set for docket sounding? Does anybody know? Ms. Knowles here is going to, Mr. Mattiliano, Judge, if the chalkboard is accurate, it says pre-trial August 3rd. The court, well, we have pre-trials August 3rd and August 31st. All right. So I would like to be able to make a decision right here and now, but I'm unable to do so. You've all presented some compelling arguments on both sides. As I noted earlier, there's at least 3 pleadings, a motion, a response, a reply. Obviously, it's a very serious issue, and so I need to take it under advisement. So that's what I'm going to do. When I'll be able to generate a decision, I'm going to certainly try to do it sooner rather than later, but I can't say definitively. So, Ms. Higgins, you had something you wanted to say? Ms. Higgins, yes, Your Honor. I believe Mr. Ballarotto and I will both be out of town on August 3rd, so I was just wondering perhaps if we could continue it and then just do a pre-trial or a status conference with the court after the court makes its ruling. But we're both going to be out on August 3rd. Mr. Ballarotto, not together, Judge. The court, I didn't think that was the implication, but you clarified that. Ms. Higgins, definitely not together. The court, well, my proposal would be, then, unless the state is objecting, is that we continue it to the 31st, which would be the next pretrial after that, and I'll definitely have a ruling by that time. And if it's a denial, then I think we need to be prepared to identify a trial date. And, obviously, if it's granted, then I guess the state goes back to the drawing board. But that would give me ample time. That would, Mr. Mansfield, that's fine. We have no objection to that. I think we've got a couple other cases we're going to go in front of Your Honor on. The court, okay. So Mr. Tucker is appearing by phone so we don't have to worry about him being aware, you know, waving. He's here telephonically. So that's what I'll do. I'll take this under advisement. I'll continue to the 31st. And I will have a decision by the time the 31st comes around. If not, beforehand. So unless there's something else from anybody, court's adjourned. Mr. Ballarotto, thank you, Your Honor. Ms. Higgins, thank you, Your Honor. The court, I'm going to go hang up the phone now, Mr. Tucker. The defendant, thank you, Your Honor. The court, you're welcome. We'll stand in recess, then. Proceedings concluded at 3:13 p.m. Court Reporter's Certificate, State of Florida, County of Monroe. I, Julie Wiktorek, registered professional reporter, certify that I was authorized to and did stenographically report the foregoing proceedings and that the transcript is a true and complete record of my stenographic notes. I further certify that I am not a relative, employee.
Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll play it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you, choking's overdue. Come at me and you won't get any older, dude, crack your holder too. Heating up inside of me, blood so violently, thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty.